Sir, now Supreme Court has granted condition bail to Senthil Balaji. Can you please explain this case in detail?
Yes, Namit. Senthil Balaji, the former Minister of Tamil Nadu, has actually got bail today in the Prevention of Money Laundering Act 2002 case. The bail has been granted by the Supreme Court, comprising the bench of Justice Abe Oka and Justice Augustine George Messiah. They are the bench who granted the bail to Senthil Balaji. If you see, Senthil Balaji got arrested in the month of June 2023, exactly on 13 June 2023. They say he has been in the prison for about 471 days, more than 40 to 50 times. His custody got extended. So finally, Senthil Balaji has got bail today. And if you see, Senthil Balaji, moment he got arrested, he started raising pertinent question of law through various petitions from the trial court to the Supreme Court. The first of the petition that Senthil Balaji filed was a writ of habeas corpus petition, wherein he questioned his arrest on various grounds of the Prevention of Money Laundering Act 2002. Second thing, that he started applying for the bail on medical condition, because we all know Senthil Balaji suffered out of a medical illness and medical emergency after he got arrested. And then he also underwent a bypass surgery, for which we all know what all happened in his health. Subsequently, he applied bail on the medical condition also. He was denied bail. And Supreme Court said, you have to go back to the trial court to apply the bail. Again, the second round of bail application, Senthil Balaji started making from the trial court, then he went to the High Court, and then subsequently now the Supreme Court. When Senthil Balaji applied the bail in the trial court, he was denied the bail, and subsequently applied the bail in the High Court in the month of February 2024. And Madras High Court denied his bail again. And two important factors what they provide as an observation, that he continuing as a minister, when they rejected his bail, the Madras High Court in its order clearly stated the reason for rejection is he continuing as a minister. To his own brother Sathya Kumar has not surrendered. There could be a flight risk. And third important thing is his contact with the Income Tax Department, which happened recently, last before year, when the Income Tax Department officials were attacked by his supporters when they went for search in the Karur. So all these things were highlighted as part of the Madras High Court judgment, and Senthil Balaji immediately resigned as a minister. And of course, there is no bar as per Representation of People Act to continue as a minister, because he is eligible to be a MLA, because he is only an accused in the Prevention of Money Laundering Act 2002. The point to be noted here, Navneet, first of all, why did Enforcement Directorate start investigation under the Prevention of Money Laundering Act 2002 on Senthil Balaji, to be understood very clearly. Senthil Balaji was a transport minister when ADMK government was in power. At that time, he brought in a scheme, that the scheme is been observed as by Madras High Court. The scheme has been highlighted as job for sale scam. That scheme, in which he announced for various job placements in his department, that is transport department, the allegation is he collected money through his brother and other supporters, and then he assured and promised them that he will provide the employment. Subsequently, he was not able to fulfill the promises, and at that point of time, the opposition to ADMK was DMK, and DMK pursued case on Senthil Balaji. So the point to be noted here, today DMK is saying Enforcement Directorate is acting with the political objective. That is not the case. Enforcement Directorate is doing its duty because it is an investigation based on Supreme Court judgment that came in May month, wherein it is an application made by Senthil Balaji to Supreme Court. In its observation came, even though predicate offence investigation would have got over, fresh investigation can start under the Prevention of Money Laundering Act 2002. The predicate offence is job for sale scam, wherein he made promises to get a job, but he didn't fulfill those promises. The aggrieved went to the Supreme Court, and the Supreme Court also expanded the definition of aggrieved to say even those people, it is not those people who applied for the job who did not get the job, who is an aggrieved, but also those people who are meritorious who did not get the job because Senthil Balaji gave jobs to many people by taking money. They are also aggrieved. Accordingly, Supreme Court gave this observation saying that in the month of May, wherein they said that even though the investigation would have got over under predicate offence, still fresh investigation can be carried forward in the Prevention of Money Laundering Act 2002. Accordingly, Enforcement Directorate, based on the observation of the Supreme Court, started the investigation in the month of June month, arrested Senthil Balaji, and it's been 471 days that Senthil Balaji was in the custody. But now, when the argument happened in the Supreme Court with respect to Senthil Balaji's bail, it is argued by the advocates of Senthil Balaji that Senthil Balaji has been there for 471 days. Second, the Enforcement Directorate said that the hard disk that they seized was Seagate hard disk, but actual hard disk that they seized was HP hard disk is the submission of Senthil Balaji's advocate. Second, the counsel of Senthil Balaji also made a submission saying that the excess income which Enforcement Directorate claims to be the money laundered by him into his bank account is actually not the money laundered, but it has a source of income. The source of income is agriculture income. A. Two, the salary being a minister. So they made these two submissions, but these two submissions as of now they have made it as part of the bail arguments, but it will have a greater implication when this is going to be compared with the nomination papers filed by Senthil Balaji in compliance with Representation of the People Act 1950 when he contested for the election. That means he has given an affidavit. That affidavit compared to his submission to the Supreme Court now with respect to bail will definitely be questioned in the future. That is second important thing. Third important thing, which is a important question of law under the Prevention of Money Laundering Act 2002, which was raised by Counsel of Senthil Balaji, is that there are three predicate offences which I have already spoken in multiple times in various interviews that I had. There are three predicate offences and one Prevention of Money Laundering Act case on Senthil Balaji which Enforcement Directorate is investigating. The question here is whether the Prevention of Money Laundering Act case relates to one of the predicate offence or relates to all the three predicate offence. This is the question of law. If this is the question of law, the answer is if it relates to all the three predicate offence has to be clubbed first. Then in one of the predicate offence, more than 1,000 people has been added and they have to be examined as witnesses and then they have to come to the court. It will take a long time for completion of trial. The second argument, the question that was raised in the Supreme Court was, if in case that case where 1,000 people are added is excluded, then can the two predicate offences be clubbed? For this Prevention of Money Laundering Act case is the question. So essentially, the summary of the issue is whether three predicate offence has to be clubbed and the Prevention of Money Laundering Act case has to be splitted according to each of the predicate offence. So there should be a clubbing of the predicate offence or splitting of the Prevention of Money Laundering Act 2002 case. So this was a question that was going on in the Supreme Court. Multiple arguments happened. The petitioner side, that is Senthil Balaji side counsel also argued the matter. Enforcement Directorate also opposed the bail because as per section 45 of the Prevention of Money Laundering Act 2002, there are two stringent conditions of the act which clearly says under the Prevention of Money Laundering Act 2002, section 45 is an important point to be noted, Navneet. Section 45 of the Prevention of Money Laundering Act clearly mentions two important twin conditions. That is, offences to be cognizable and non-bailable. Wherein subsection 1 clearly says, notwithstanding anything contained in the Code of Criminal Procedure 1973, no person accused of an offence shall be released on bail or on his own bond unless A, that is the public prosecutor has been given an opportunity to oppose the application for such release, and 2, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. So this is the two condition which has to be satisfied for bail. Based on this satisfaction, Senthil Balaji has got the bail. But however, if you see in Supreme Court, recently the jurisprudence with respect to Prevention of Money Laundering Act 2002 is changing. If you see, based on Y.S. Jaganmohan Reddy versus CBI in 2016, clearly said economic offences are crime against society. Accordingly, jail is a norm, bail is an exception. But whereas recently in the Supreme Court, if you observe the bail orders, wherein the Supreme Court has held very clearly the bail condition in Prevention of Money Laundering Act 2002, section 45, cannot be against Article 21, 20 of Constitution of India. Even Article 22. Article 20, Article 21, Article 22 of the Constitution of India is the basis of liberty to a person. Accordingly, by harmonizing Constitution of India article with the section 45 of the Prevention of Money Laundering Act condition, what we can understand is liberty is a norm, deprivation is an exception. Accordingly, bail is a norm, jail is an exception. Even in case of Prevention of Money Laundering Act 2002 is the observation that we can see the Supreme Court has given in the recent judgments that came with respect to bail. So accordingly, these observations are very important evolution of the Prevention of Money Laundering Act case, even in the Supreme Court judgments. These observations has to be looked into. However, in case of Senthil Balaji case, bail has been granted with certain condition.
So what are the conditions that pointed out on the bail, sir?
Yes, Navneet. Of course, the full order copy has to be uploaded in the website, but the order copy has not yet come. Accordingly, what we need to understand from the advocates who spoke on behalf of Senthil Balaji in various media channels, they have mentioned about important point to be noted. Senthil Balaji has to go to the Enforcement Directorate at least twice in a week and sign. And then second, he should surrender his passport because there could be a flight risk. And third important condition, that the Senthil Balaji should not tamper any evidences or witnesses. These are primarily, we can understand this from the counsels who spoke in the television.
Sir, is there any legal problem on Mr. Senthil Balaji becoming minister again? Because many people comparing judgment of Arvind Kejriwal to this Senthil Balaji judgment, sir.
Right. Navneet, if you look at the laws surrounding a legislator, when I say legislator, politicians who are part of the legislative or legislative assembly or member of the parliament, that is MLA, as per the Representation of the People Act 1950, just because he is named in a particular case as an accused or there are allegations on him, including Prevention of Money Laundering Act 2002 or Prevention of Corruption Act or case of Senthil Balaji kind, there is no bar or prohibition as Representation of the People Act 1950 that he cannot continue as a minister. In fact, there is no restriction at all. So, the allegation at this stage is only accused in the case. Only on the judgment, after the trial, we can know whether it is a conviction or acquittal. It is a power of the court to decide on this matter. So, accordingly, as per the Representation of the People Act, he is not disqualified to be a member. When he is not disqualified to be a member, that is MLA, then he can be a minister. So, if you ask me whether he can become a minister, answer is yes, he can become a minister. But whether DMK in the present situation will make him a minister is the first question. Considering that already the portfolios are allotted, of course there is a talk going on that there is going to be a shuffle in the portfolio, and even Udayanidhi Stalin is expected to become the deputy chief minister and all those things. So considering this fact, there is a possibility that the DMK may even allot him a particular portfolio. Our point to be noted, Senthil Balaji's health condition, as he has reported as part of the bail application, wherein he has undergone surgery, his medical condition he has explained. So multiple times he has explained to the court. If the fact of the matter, if the medical issues of Senthil Balaji is serious, then how can he execute the work? So he will have constraint in executing the work of the minister. So he himself may not take it up. So we have to wait and watch whether Senthil Balaji is going to take up the ministership or he is going to carry on the work of the party in strengthening the party in Kongunadu, or even we don't know whether he will change the party, whether he will shift the party. That is his personal choice, because in politics nothing is permanent, and especially with respect to Senthil Balaji, nothing can be permanent, because he was in ADMK, then subsequently he moved to yet another party, and then he moved to DMK further. So whichever party comes to power, or if Senthil Balaji sees that there is one party which can come to power, he will align and negotiate and see to that he continues in the power. For Senthil Balaji, it is all about being in power. It's not about the party. For him, power is permanent. For him, the focus is power, but the party is a transitional aspect. So if you ask me, is there a loyalty towards any party that Senthil Balaji might have? He doesn't have a loyalty to any of the parties, because he has changed the parties often, and that has happened in a short period of time, and he is young also, because he became a minister at the age of 39, I suppose, when he became the first time minister in the ADMK government. But of course, he was removed later point of time by the leader of the ADMK. So considering all these factors, Senthil Balaji is loyal to the power, not loyal to the party. So the point to be noted here, there are many seniors of the DMK who are much more seasoned politicians, who are all waiting for the positions in the party, who has dedicated their life for the Dravidian movement. So who has to be given importance, has to be evaluated at this juncture. And Senthil Balaji, whether he requires a rest because of his medical condition, or Senthil Balaji will take up the powerful ministries, or whether he will be allotted again, is the next question. Third, already when Senthil Balaji is surrounded by controversy, again putting him in a minister, especially he was a minister when he was arrested for TASMAC and electricity. And TASMAC, when he entered itself, allegations started on him saying the 10 rupees is collecting over and excess of the price of the liquor. So these issues will further have a drastic implication on DMK. So definitely the leadership of DMK will evaluate the options to see to that whether Senthil Balaji will become minister or not. But that is not the mandatory condition. Nothing can be said until the leadership of the DMK decides to provide him the power. But point to be appreciated is DMK stood by his side. DMK stood on the side of Senthil Balaji, supported him with respect to all his cases. For Senthil Balaji, loyalty should not change to the DMK. Because he should be loyal to DMK because DMK supported him now. Even though DMK actually pursued the case against him when he was in ADMK on the same matter. But on the same matter, when he was arrested by the Enforcement Directorate, the entire legal support is provided by the DMK. So accordingly, leadership of DMK at this juncture is in support of him. But the question is whether he will get the powerful post just the way he was in the powerful post before he got arrested is definitely a question of time. So we have to wait and watch like anybody who is looking at what will be the next course of action for Senthil Balaji. But all that is we have to understand is Senthil Balaji is not loyal to any party or any person, but he is loyal to the power and money, which we can understand and decipher from his actions over a period of last 10 years and the allegations that he has got into with respect to the job for sale scam. So these are some of the issues that is going to be seen. But however, his case has not come to an end. He has only got a bail. Definitely his supporters are celebrating in his region. His supporters, when I say his supporters, not that all DMK party workers are celebrating his bail, but his supporters are celebrating in his Kungu region because they are his supporters. Senthil Balaji case has not come to an end. He has only got a bail from the Supreme Court. The case will definitely, trial will commence any point of time. There are 3 predicate offences. One Prevention of Money Laundering Act case, that is ECIR has been filed on him. So these things has to come to a conclusion. The judiciary has the ultimate say on the matter. After the trial, whether he will get convicted or acquitted, it will be surely based on the judgment that can come only after the trial. We have to wait and watch until that point of time.
Sure, sir. Thank you for your valuable time.
Thank you, Navneet.